Hey everybody, we are back in the shanty, but we're not back in the shanty, are we? You know that's not the background of the shanty. It's actually the background of one of our conference rooms here in our beautiful downtown Grand Rapids offices. Why am I doing a shanty from a conference room in one of our beautiful downtown Grand Rapids offices? Which I don't like to do because the lighting here is better, and I got a face made for radio, not for video, that's for sure. Well, I'm doing a shanty from one of our conference rooms in our beautiful downtown Grand Rapids offices for two reasons. First and foremost, the shanty is being renovated, which is why I was in the office today when the Michigan Supreme Court, in its infinite wisdom, dropped its mothering justice opinion. That is the second reason that I am doing a shanty from a conference room in our beautiful downtown Grand Rapids offices. What, may you ask, is the mothering justice opinion? Some of you might not remember. I wouldn't be surprised if you didn't. The mothering justice opinion is an opinion that dealt with the issue of the legislature's strategy of what's called adopt and amend. Now, some of you may remember this from when it happened the first time, and some of you may not. And we've been through this a couple of times at the Court of Claims and at the Court of Appeals. But adopt and amend happens when the legislature takes a ballot initiative. And we have an initiative process here in Michigan whereby citizens, if they get enough signatures, can take something and put it on the ballot for a vote. The legislature has a right, when that occurs, to do a couple of things. One of those things is to adopt the proposed legislature, the ballot initiative, as written. And that's what the legislature did back in 2018 with two statutes that are important to you. One is the Minimum Wage Act, a bunch of changes to the Minimum Wage Act. And two is the Earned Sick Time Act, which ultimately gave us what we now call the Paid Medical Leave Act. So what the legislature did back in 2018 was they adopted these statutes in their entirety as they were written, which they were required to do by the Constitution. But then what they did is during the same legislative session, they completely amended the statutes. So as some of you may or may not remember, the Paid Medical Leave Act doesn't look anything at all like what the Earned Sick Time Act looked like, except that it provides paid medical leave to certain employees in the state of Michigan. And the legislature modified the minimum wage statute quite a bit too. The question before the Supreme Court that had been answered by the Court of Claims and the Court of Appeals was, is that constitutional? Can the legislature adopt this amendment or initiatives, these initiatives, and then change them, amend them during the same legislative session? And what the Michigan Supreme Court said today was, no, they can't do that. It is unconstitutional. Now, I'm not going to go through the majority opinion is like 35 pages long. The entire opinion with concurring opinions and syllabus and dissenting opinions and all that jazz is 105 pages long. I'm not going to go through all that nonsense with you. So why am I telling you this? I'm telling you this because you guys are HR people and you are now going to have to deal with the aftermath of this decision, because the aftermath of this decision is the current minimum wage law going away, the current Paid Medical Leave Act going away, and they are going to be replaced by the laws that were written as ballot initiatives, which means we're now going to have a graduated increase in the minimum wage that was originally planned, which is different than the one we have now. And it means we're going to have the Earned Sick Time Act, which is significantly different from the Paid Medical Leave Act. So when does this all go down? Do I have to do it now, today? If it was unconstitutional, do I have to do it today? Well, the answer is no. The court, in their opinion, has given us 205 days to comply before the statutes go into effect. So basically, you have 205 days to get your ducks in a row and get everything the way it needs to be. Now, 205 days from today is like February 21st, okay? I'm not a math whiz, so it could be off a day or two, but it's February 21st. So by February 21, 2025, these new old laws are going to go into effect, and the old new laws are gone. What does that mean? Well, let's start with the minimum wage law, even though most of you pay more than the minimum wage anyway. The minimum wage law has a graduated increases in the minimum wage, fixed graduated increases in the minimum wage. Originally, those started like in 2019 and ended in 2023. Well, we're past that now. So the court had to put a new schedule in place, right? I mean, we obviously can't raise it, and they weren't going to go right to the highest minimum wage, so they put a new graduated schedule in starting February of 2025 and ending in February of 2029, at which time the minimum wage becomes indexed and it increases every year. And the other thing that happens is the tip credit goes away. For those of you that have tipped employees, you know what that is. In 2029, the tip credit is going away in February of 2029. As far as the Earned Sick Time Act goes, the Earned Sick Time Act is going to replace the Paid Medical Leave Act. Big deal? Not big deal. It's a big deal because the Earned Sick Time, if you recall it, is significantly different and more onerous than the Paid Medical Leave Act. For example, the Paid Medical Leave Act only applies to you if you have 50 or more employees. The Earned Sick Time Act applies to so-called small employers, 1 to 9 employees, and large employers, 10 or more employees. It gives different benefits, amounts of paid sick time to those people. Paid sick time is earned based on the number of hours you work, 1 hour accrued for every 30. If you're a small employer, 1 to 9 employees, you have to give 40 hours of paid sick time a year. If you're a large employer, 10 or more employees, you have to give 72 hours of paid sick time a year. That's more than you currently do under the Paid Medical Leave Act, even if you're a large employer. There's other distinctions, like under the Paid Medical Leave Act, you can give sick time in 1 hour increments. Under the Earned Sick Time Act, it's in the smallest amount of time that your time-keeping system keeps time. For many of you, that's a quarter of an hour. For some of you, it's a tenth of an hour. So those kind of changes are going to have to go into place. Now, again, I don't want you to panic, and we're not going to get into a whole bunch of detail about what this means for you now and what you have to do, because we have 205 days to get our ducks in a row. And you're going to see a bunch of email from us, probably an eAlert on this very topic, but a bunch of email from us on seminars and webinars and all kinds of stuff that we're going to do to help you get in compliance. And fortunately for you, and fortunately for us, we've done a lot of work on this already, because the Court of Claims originally said that what the legislature did was unconstitutional. And then the Court of Appeals said, no, it was constitutional. And now the Supreme Court has said it's unconstitutional. So we're kind of right back where we started from. So if a lot of this sounds like deja vu all over again, as good old Yogi Berra said, it is, because we've gone through this exercise before. So no need to panic, but do know that the minimum wage law is going to change in 205 days. The PMLA is going to win. It's going to be replaced by the Earned Sick Time Act in 205 days, and we need to start planning. So keep an eye on your emails, keep an eye on our website, and keep an eye on when these webinars and seminars and things like this are going to happen, and we'll help you get them in compliance. If you have any questions, give us a call, and we'll be happy to answer them for you. See you next time from the Shanty.